Welcome to our mandatory training on sexual harassment prevention. My name's Andy Green, and I'm the Vice President of Human Resources at IRG Realty Advisors. As we all know, recently the topic of sexual harassment has been brought into the national spotlight, bringing with it an awareness of the seriousness and unacceptable nature of such behavior, as well as the severe consequences that follow. The term sexual harassment means different things to different people, and that's why we're here today. What seems appropriate, or perhaps has seemed appropriate in the past, is not always acceptable to the people with whom we work. The purpose of today's training is to establish a common understanding of what is and what is not acceptable behavior in the workplace. IRG Realty Advisors is committed to ensuring that all individuals have an equal opportunity to enjoy a fair, safe, and productive environment. Our company policies help ensure that diversity is respected and that everyone has the privilege of working in a safe environment. Preventing harassment of any type, especially harassment that's sexual in nature, is critical to our company core values and our continued success, and it will not be tolerated. This means that any harassing behavior will be investigated and the perpetrator or perpetrators will be told to stop. It also means that disciplinary action, if appropriate, will be taken. Furthermore, if the behavior is sufficiently serious or repeated after being told to stop, disciplinary action may include termination. Today's training will help you better understand what is considered sexual harassment. It will also cover how to report sexual harassment in our workplace, as well as your options for reporting it to state and federal agencies that enforce anti-discrimination laws. What is sexual harassment? Sexual harassment is a form of sex discrimination and is unlawful under federal, state, and where applicable, local law. Sexual harassment includes harassment on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. Sexual harassment includes unwelcome conduct, which is either of a sexual nature or which is directed at an individual because of that individual's sex when it has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment, even if the reporting individual is not the intended target of the sexual harassment. It is made explicitly or implicitly a term or condition of employment, or submission to or rejection of such conduct is used as the basis for employment decisions affecting an individual's employment. There are two types of sexual harassment. The first type is referred to as hostile environment. Hostile environment on the basis of sex may be created by any action previously described. In addition to unwanted words, signs, jokes, pranks, intimidation, physical actions or violence, either of a sexual nature or not a sexual nature, directed at an individual because of that individual's sex. Hostile environment sexual harassment includes sexual or discriminatory displays or publications anywhere in the workplace, such as displaying pictures, posters, calendars, graffiti, objects, promotional material, reading materials, or other materials that are sexually demeaning or pornographic. This includes such sexual displays on workplace computers or cell phones and sharing such displays while in the workplace. This also includes sexually oriented gestures, noises, remarks, jokes, or comments about a person's sexuality or sexual experience. Hostile actions taken against an individual because of that individual's sex include rape, sexual battery, molestation, or attempts to commit these assaults. Physical acts of a sexual nature, including but not limited to touching, pinching, patting, grabbing, kissing, hugging, brushing against another employee's body, or poking another employee's body. Interfering with, destroying, or damaging a person's workstation, tools, or equipment, or otherwise interfering with the individual's ability to perform the job. Sabotaging an individual's work, bullying, yelling, and name-calling. The second type of sexual harassment is called quid pro quo. Quid pro quo sexual harassment occurs when a person in authority trades or tries to trade job benefits for sexual favors. Quid pro quo is a legal term meaning a trade. This type of harassment occurs between an employee and someone with authority, like a supervisor, who has the ability to grant or withhold job benefits. Quid pro quo sexual harassment includes offering or granting better working conditions or opportunities in exchange for a sexual relationship, threatening adverse working conditions like demotions, shift alterations, or work location changes, or denial of opportunities if a sexual relationship is refused. Using pressure, threats, or physical acts to force a sexual relationship, retaliating for refusing to engage in a sexual relationship. Who can be the target? Sexual harassment can occur between any individuals regardless of their sex or gender. The law protects employees, paid or unpaid interns, and non-employees, including independent contractors and those employed by companies contracting to provide services in the workplace. Who can be the perpetrator of sexual harassment? The perpetrator of sexual harassment can be anyone in the workplace. It can be a coworker, a supervisor, or a manager. It could also be any third party, including a non-employee, intern, vendor, building security, client, customer, or visitor. Where can workplace sexual harassment occur? Harassment can occur whenever and wherever employees are fulfilling their work responsibilities, including in the field, at any employer-sponsored event, trainings, conferences open to the public, and office parties. It can also include employee interactions during non-work hours, such as at a hotel while traveling, or events after work that can have an impact in the workplace. Locations off-site and off-hour activities can be considered extensions of the work environment. Employees can be the target of sexual harassment through calls, texts, emails, and social media. It's important to note that harassing behavior that in any way affects the work environment is rightly the concern of management. Sex stereotyping. Sex stereotyping occurs when conduct or personality traits are considered inappropriate simply because they may not conform to other people's ideas or perceptions about how individuals of either sex should act or look. Harassing a person because that person does not conform to gender stereotypes as to appropriate looks, speech, personality, or lifestyle is sexual harassment. Harassment because someone is performing a job that is usually performed or was performed in the past, mostly by persons of a different sex, is sex discrimination. Retaliation. Any employee who is engaged in protected activity is protected by law from being retaliated against because of that protective activity. Protected activities with regard to harassment includes making a complaint to a supervisor, manager, or another person designated by IRG Realty Advisors to receive complaints about harassment, making a report of suspected harassment, even if you are not the target of the harassment, filing a formal complaint about harassment, opposing discrimination, assisting another employee who is complaining of harassment, providing information during a workplace investigation of harassment, or testifying in connection with a complaint of harassment filed with a government agency or in court. What is retaliation? Retaliation is any action taken to alter an employee's terms and conditions of employment because that individual engaged in any of the above protected activities. Such individuals should expect to be free from any negative actions by supervisors, managers, or the employer motivated by these protected activities. Retaliation can be any such adverse action taken by the employer against the employee that could have the effect of discouraging a reasonable worker from making a complaint about harassment or discrimination. The negative action need not be job-related or occur in the workplace, and it may occur after the end of employment, such as an unwanted negative reference. What is not retaliation? A negative employment action is not retaliatory merely because it occurs after the employee engages in protected activity. Employees continue to be subject to all job requirements and disciplinary rules after having engaged in such activity. The supervisor's responsibility. Supervisors and managers are held to a high standard of behavior, and this is because they've been placed in a position of authority and they must not abuse that authority. Their actions can create liability for the company without us having an opportunity to correct the harassment. Furthermore, supervisors and managers are required to report any harassment that is reported to them or which they observe. And they're also responsible for any harassment or discrimination that they should have known of with reasonable care and attention to the workplace for which they are responsible. And finally, we expect them to model appropriate workplace behavior. Mandatory reporting. Supervisors must report any harassment that they observe or know of, even if no one is objecting to the harassment. If a supervisor or manager receives a report of harassment or is otherwise aware of harassment, they must promptly report it to management without exception, even if the supervisor or manager thinks the conduct is trivial, and even if the harassed individual asks that it not be reported. Supervisors and managers will be subject to discipline for failing to report suspected sexual harassment or otherwise knowingly allowing sexual harassment to continue. Supervisors and managers will also be subject to discipline for engaging in any retaliation. What should I do if I'm harassed? We cannot stop harassment in the workplace unless we know about it, and it's everybody's responsibility. We strongly encourage you to report any harassment to your supervisor or HR department so that the company can take action. Behavior does not need to be a violation of law in order for it to be a violation of company policy. We will provide you with a complaint form to report harassment and file complaints. But if you're more comfortable reporting it verbally or in another manner, we are still required to follow the sexual harassment prevention policy by investigating the claims. If you believe that you have been subjected to sexual harassment, you are encouraged to complete the complaint form and submit it to the HR department. You may also make reports verbally. Once you submit this form or otherwise report harassment, our company must follow its sexual harassment prevention policy and investigate any claims. You should report any behavior you experience or know about that is inappropriate as described in this training, without worrying about whether or not it is unlawful harassment. Individuals who report or experience harassment should cooperate with management so a full and fair investigation can be conducted and any necessary corrective action can be taken. If you report harassment to your manager, the HR department, or supervisor and receive an inappropriate response, such as being told to just ignore it, you may take your complaint to the next level as outlined in our policy under legal protections and external remedies. Finally, if you're not sure you want to pursue a complaint at the time of potential harassment, document the incident to ensure it stays fresh in your mind. What should I do if I witness sexual harassment? Anyone who witnesses or becomes aware of potential instances of sexual harassment should report it to their supervisor immediately. While it can be uncomfortable and scary, it's important to tell coworkers that's not okay when you're uncomfortable about harassment happening in front of you. It's unlawful for an employer to retaliate against you for reporting suspected sexual harassment or assisting in any investigation. Investigation and corrective action. Anyone who engages in sexual harassment or retaliation will be subject to remedial and/or disciplinary action up to and including termination. IRG Realty Advisors will investigate all reports of harassment, whether information was reported in verbal or written form. An investigation of any complaint should be commenced immediately and completed as soon as possible. The investigation will be kept confidential to the extent possible. Any employee may be required to cooperate as needed in an investigation of suspected sexual harassment. Again, it's illegal for employees who participate in any investigation to be retaliated against. Investigation process. Our organization also has a duty to take appropriate steps to ensure that harassment will not occur in the future. Here is how we will investigate claims. The manager, HR department, and president will conduct an immediate review of the allegations and take any interim actions as appropriate. Relevant documents, emails, or phone records will be requested, preserved, and obtained. Interviews will be conducted with parties involved and witnesses. The investigation will be documented as outlined in the sexual harassment policy. Also, the individual who complained and the individual accused of sexual harassment are notified of final determination and that appropriate administrative action has been taken. Additional protections and remedies. In addition to what we've already outlined, employees may also choose to pursue outside legal remedies. If you're a resident of New York, a complaint alleging violation of human rights law may be filed with the DHR or in New York State Department Supreme Court. Complaints may be filed with DHR at any time within 1 year of the alleged sexual harassment, and you do not need to have an attorney to file. If an individual did not file at DHR, they can sue directly in state court under the human rights law within 3 years of the alleged sexual harassment. An individual may not file with DHR if they have already filed a human rights law complaint in state court. For more information, visit www.dhr.ny.gov. Additionally, an individual can file a complaint with the EEOC anytime within 300 days from the alleged sexual harassment, and you do not need to have an attorney to file. A complaint must be filed with the EEOC before you can file in federal court. For more information, visit www.eeoc.gov. Local protections. Many localities enforce laws protecting individuals from sexual harassment and discrimination. You should contact the county, city, or town in which you live to find out if such laws exist. Harassment may constitute a crime if it involves things like physical touching, coerced physical confinement, or coerced sexual acts. You should also contact the local police department. Other types of workplace harassment. Workplace harassment can be based on other findings and is not just about gender or inappropriate sexual behavior in the workplace. Any harassment or discrimination based on a protected characteristic is prohibited in the workplace and may lead to disciplinary action against the perpetrator. Protected characteristics include age, race, creed, color, national origin, sexual orientation, military status, sex, disability, marital status, domestic violence victim status, gender identity, and criminal history. Much of the information presented in this training applies to all types of workplace harassment. Now that the training has concluded, we should all understand how to recognize harassment as inappropriate workplace behavior. We should be able to recognize the nature of sexual harassment, that harassment because of any protected characteristic is prohibited, why workplace harassment is employment discrimination, that all harassment should be reported, and that supervisors and managers have a special responsibility to report harassment. Lastly, you can find the complaint form by logging into your Bamboo account and clicking on the Files tab. With this knowledge, we all can achieve appropriate workplace behavior, avoid disciplinary action, know our rights, and feel secure that we are entitled to and can work in an atmosphere where all people are respected. Thanks for watching this training video and for taking sexual harassment serious. For additional information or questions, please call or email me.